Welcome back to the fourth and final episode breaking down the testimony of Robyn Denholm in the class action 12711 VCS in the Delaware Court of Chancery against Elon Musk as found in trial document 468 on plainsight.org. We rejoin the proceedings following the morning recess when they restart the cross-examination. First question to Denholm after the break confirms that the Tesla board knew nothing about the bridge loan that Musk promised Lyndon Rive in May of 2016. And that the board learned about this 2 months later at the July 19th meeting, despite meetings on May 31st, June 20th, and July 5th, where this could and should have been mentioned. July 19th is the first time this bridge loan is discussed in any meeting minutes, and Denholm states that the board rejected SolarCity's request. By stating this, she is attempting to show that the board was capable of standing against something that Elon Musk wanted. And this is where we take the pin out on his point from the direct, because that is not what happened. See, Musk had already rejected the idea of a bridge loan by Tesla to SolarCity, despite making that assurance to his cousin. So any conversation the board had at that time was pointless. JX1497 is an email from Mr. Small, one of the financial officials at SolarCity, to Lyndon Rive. It reads, "Just finished call with Tesla, they're putting bridge loan completely on us." Lyndon wrote back, "Elon really does not want to do the bridge loan, which is why he's offering to buy Solivo first. He is really concerned about reputational damage." These emails were written on July 14th, 5 days before this meeting where Denholm was under the impression the board had a say in this matter. Meaning the board not only didn't stand up to Musk on this, as Denholm and Musk testified, their opinions were never even considered. And that's why we said in the direct examination, this is a bigger point than it seems. This had been played off previously as something Musk wanted that the board rejected, showing that they had the ability to tell Musk no. With this revelation, the plaintiff's lawyers have been able to prove the exact opposite is true. Moving on. Prior to the July 19th meeting, Musk and Evercore had spoken about the deal, as JX1528, emails from July 15th and 16th. Mr. Francis and Ms. McBean exchanged with her writing, "Roger just called me. I brought him up to speed and told him we are waiting to jump on a call with Elon." This call was part of the daily check-in call routine that Denholm knew nothing about, and as Berger confirms with her on page 2153, the board never asked Evercore to do daily check-in calls with the conflicted recused CEO. Denholm tries denying she knew these calls took place, and since that is the case, it's pretty obvious these calls were not sanctioned by the board. Neither were the ongoing calls between Musk and Marin and other members of Tesla management outside the presence of the board, including Wheeler. Neither Musk nor any of the persons he contacted reported to the board what these discussions were about or that they took place. JX1416, an email from July 5th, gives some indication what those discussions entailed. It's Marin to several other parties, including Wheeler and McBean. "I spoke with Elon today after our call. In part, we discussed the status of diligence and also their, and the rest is redacted. But it's enough to know that unauthorized conversations about the status of diligence were taking place with Musk, even if that content has to be speculated upon." Next meeting was July 22nd, where they met to consider the transaction, JX1655. Neither Musk nor Garcias were at this meeting, however Evercore had still sent the materials to Musk for review ahead of time. JX1619 is an email from Mr. Altman at Evercore on July 21st, the day prior, writing to his colleagues that, "On tonight's call with Elon, we need to make a recommendation, also the revised exchange ratio which we will recommend to the full board tomorrow." That phone call with Evercore was, again, not reported to the Tesla board by any involved party. Musk wasn't at that meeting, but Musk didn't need to be there. These guys were going to do his bidding regardless. It was all determined the night before in secret. 2 days later, July 24th, another meeting, JX1673 the minutes, where the offer was revised to a ratio of 0.105 to account for what they called findings in due diligence, or at least what they had managed to find. During the meeting, the bankers at Evercore were directed by the board to extend that offer to the bankers at SolarCity, and the meeting ended at 1:45 p.m. according to Denholm. However, that's not when the offer was made, and Evercore in fact waited until after they heard back from Musk to forward the offer. JX1671 records what happened. Denholm stated the meeting wrapped at 1:45 p.m. However, 12 minutes later, co-opted Marin is telling the board that he can set up a call with Musk in about 30 minutes. Then the record says, "I haven't heard back from Elon yet. I think the best bet is for me to free all of you up, and then depending on my conversation with him, we'll set up a phone call late tonight for those who can join." JX1681 is an email chain among the Evercore people, starting at 6:34 p.m. 5 hours later. Mr. Altman states, nothing to do but wait. Mr. Francis wrote, Todd just called me. They said they have a final board decision about it at 10 p.m. Then they will call me to tell us what price they decided to counter with. Then he said we will be deputized to call Lazard to communicate our offer, which will not really happen until tomorrow, given the Lazard team is East Coast based. All this took place behind the scenes after the meeting where this was supposed to have been settled by the board. Yet the bankers were sitting around twiddling their thumbs waiting for another final approval after talking again with Musk. And despite the board approving the offer at 0.105 during the meeting, the actual offer Evercore moved forward with was 0.110, 5 points higher. And Berger makes sure to solidify this point. None of what you just described happening after the meeting was disclosed in the proxy, right? Something else that Robyn Denholm cannot recall. Switching topics, Berger moves into the energy storage argument. There's been some testimony in this case by Mr. Musk that in order to have a compelling battery product, you really need to have a tightly integrated solar and battery solution. Musk testified that we actually only sell solar with a Powerwall because this is the only scalable solution. This had been a core tenet of this supposed merger since the very beginning, that everything had to be integrated. But Berger brings up another demonstrative where they charted in megawatts the company's deployments of solar systems and of storage batteries for the period of the third quarter 2016 through 2019, and the story doesn't check out. In fact, the charts show there is no relationship between its sales of battery storage systems and solar arrays. The sales of solar systems, which they had depicted as a red line, were declining and staying low all through 2019, while the sales of storage systems, battery systems, are increasing substantially, certainly since 2017, since the third quarter. Meaning in no uncertain terms that Tesla did not need to take on SolarCity to grow their energy storage sector at all. Whether that storage was commercial or residential, it made no difference. Berger also asked Denholm if she was aware Musk had tried to pawn off the failure of the solar business post-bailout on the COVID pandemic. Denholm tries the same spiel at this time, but as Berger reminds her, the pandemic did not have the same impact on the sales of solar systems versus battery packs, and battery installations still need to go through a similar permitting process as the solar install. Meaning, whatever was affecting the declining solar sales, it was not COVID, which didn't kick in until spring of 2020, and this bailout took place in November of 2016. With this exchange, Berger hands Denholm back to Chesler for a redirect that lasts for about 20 pages. As with the other witnesses, we'll skip that portion since plaintiffs found nothing of note in the discussion worth mentioning. You're welcome to read these at your leisure starting on page 2170. Which brings us to this summary of Denholm's testimony. Robyn Denholm came to Tesla in 2014 with an impressive educational history and some past board experience. She joined the Tesla board to take over the chair of the audit committee from Brad Buss after he reached out to her. In 2016, from the time this bailout was first proposed in February to when it was voted on by shareholders in November, in addition to being the chair of the audit committee, a member of the nomination and governance committee, and member of the compensation committee at Tesla, she served on no less than 3 other company boards, wrapping up a tenure at Juniper, then starting up at ABB in April 2016, then Telstra that November. In her spare time, Denholm was overseeing this bailout transaction without any designated authority to do so from the board of directors, meaning the Tesla shareholders had no empowered independent voice on the board during these negotiations. During Denholm's direct examination, her mind appeared quite sharp when answering the rehearsed questions, her answers often a simple yes or no. In cross, those answers changed quickly to I don't know and I don't recall. She claims to have headed up due diligence efforts, but failed as a professional accountant to discover what a financial disaster SolarCity had become, as was shown both before and after the bailout vote by professional analysts. She claims to have discussed the deal directly with shareholders and advocated they pursue the deal, despite her role requiring her to be a disinterested independent director in the matter. She claims she would have voted against the deal if it became obvious that the deal was not in Tesla's best interest. Yet she completely ignored the 100% accurate assessments provided to her by Barclays and Glass Lewis and any other number of articles outlining the problems with this bailout. She claims Musk was recused, yet she required his constant counsel in the room during discussions and presentations to understand the basics of this deal. She claims Musk took no part in the discussions of importance, yet Musk attended almost every meeting, and if Musk wasn't there, Evercore was to report back to him. As the Tesla lead in this, Denholm knew nothing about Musk's conversation with Lyndon Rive about his promises to buy SolarCity through Tesla well in advance of ever bringing this to the board. She knew nothing about Musk's promise to provide bridge financing to Solar City and didn't know that Musk had already changed that arrangement long before the board ever heard about it. She knew nothing about Musk's constant contact with Evercore. She knew nothing about Musk and Gracias co-opting the company's general counsel to handpick the deal lawyers for this bailout. Yet she still voted in favor of bailing out Musk and his cousins at Solar City, to the tune of $6 billion in a stock and debt transaction. And as it turns out, Denholm was never empowered by the board to act on the company's behalf as a disinterested independent facilitator, meaning that in this multi-billion-dollar deal, the Tesla shareholders had nobody representing a neutral opinion on the deal, looking out for their best interest, which were definitely not served in this bailout. We asked at the beginning of the direct examination of this witness, was Robyn Denholm, the current chair of the board at Tesla, the woman the SEC currently expects to keep Musk in check to avoid further legal action against Musk and Tesla? We asked if, in regards to this bailout, was she complicit or incompetent? And the answer is, without a doubt, she was both. She's incredibly lucky she was able to settle out of court prior to this trial through the directors and officers insurance policy Tesla had at the time but has no longer. Otherwise, who knows how much she would have had to pay from the 688 million Aussie dollar fortune she's managed to amass since joining Tesla in 2014. Now, it seems obvious to us, but this is purely speculation on our part, that the defendant's lawyer, in theory the friendly team for the witness, tried their very best to set the responsibility for Tesla's action in this transaction firmly on Ms. Denholm's shoulders. And why wouldn't you? Denholm had already settled, right? Having settled in this instance, the court cannot apply any further penalty to her, so why not try to use her resulting immunity to Musk's advantage? Have her say she picked the lawyers. Have her say she picked the bankers. Have Musk tell the court that she was in charge, despite meeting minutes, emails, and other evidence that contradict every one of those points. However, no matter how complicit Denholm was, no matter how incompetent she is, it does not change the facts in the case surrounding Musk, his actions, and his obvious influence over this deal from both sides. The plaintiffs were tasked in the very beginning of this trial to meet this burden, to prove that Musk had the ability to influence the board into moving forward with the bailout. They do not have to prove that he used that influence, only that it was within his ability to do so. And as we wrap up the last witness we're going to cover for this trial, it's extremely obvious that not only did Musk have the ability to influence the board, he used and abused that ability at every turn. Now, we promised a summary of this trial to wrap everything up in a bow, and we're going to do that in a separate episode, because we managed to receive the plaintiff's post-trial argument document, so that anyone looking for that information can find it as a standalone video. This document is absolutely stunning and is coming up next.